Hello, my name is Trey Flournoy, and I'm an attorney with the Bush Law Group. What I'd like to do next is to continue our discussion on the constant and repeated seepage exclusion provision in the policy. And again, we're talking about the context of a water loss that potentially has been going on for more than 14 days. And so I want to give you a little bit of case law so that you understand how courts are often ruling on this type of provision when interpreting it. The first case I want to talk about is the Hicks versus American Integrity Insurance Company case. This is a Florida case, and that court held that the policy language stating that we do not insure for loss caused by constant or repeated seepage or leakage of water over a period of 14 days or more did not preclude coverage for damage caused during the first 13 days of the leak. Another case is the Whiteley versus American Integrity Insurance Company case. And that's a 5th DCA case in the state of Florida as well. And the DCA, in its appellate capacity, ruled in accordance with the Hicks case that I just mentioned. And the court rejected the carrier's interpretation of the 14-day repeated seepage exclusion in the policy. In the Whiteley case, the insured made a claim for a water release event in their vacation home, which continued for about 30 days. Well more than the 14-day provision in the policy. The insurance company denied the claim under the constant or repeated leakage and seepage exclusion. After the trial court entered summary judgment for the insurance company based on the exclusion, the case went up to appeal and the 5th DCA reversed the trial court. The DCA held that the insurer, the insurance company, had the burden of establishing that the exclusion applied, and so the insurance company also bore the burden of proving that no loss occurred during the first 14 days. The next thing I want to do is talk about the constant and repeated seepage provision in the context of a rain loss. And what I mean by rain loss is, what if you have perhaps a leak in a roof and you have rain that has entered into the building over a period of time? Sometimes you'll see that the insurance company will want to deny that loss on the basis of the repeated seepage exclusion. That issue came up before the Bartram LLC versus Landmark American Insurance Company, and that's a federal case in the Northern District of Florida. And that court ruled that it was undisputed that the water damage in this case was caused by rain, and as a matter of law, the seepage exclusion unambiguously does not apply to losses caused by rain. The court reasoned that unless the water seepage is coming from a fixed source, such as a plumbing, heating, or air conditioning, it is difficult to make sense of the language in the policy, stating that the excluded water seepage must occur continuously or repeatedly for 14 days or more, since the seepage from the rain would seem to be an intermittent source. The plain language of the exclusion would not make sense if applied to rain. After all, if you think about it, rain is not constant, it's intermittent, it starts and stops at various intervals, it comes in different intensity, and thus it cannot trigger the seepage exclusion. So Florida law does not allow for the interpretation of a policy provision which would yield such a nonsensical result. More on water losses to come in our next segment.